Here's top 10 mistakes that I commonly see people making in court when they are representing themselves. My name is Tracy Maloney, aka the Legal Queen on social media. I am a family solicitor practicing for the last 25 years, and I thought I would share with you some of the common mistakes that I see litigants in person, people who are representing themselves, making in court all the time. So let's jump right in. Mistake number one, make sure that you are on time. All too often, I see people who are representing themselves turning up to court late. If your hearing is set for, let's say, 10 a.m, make sure that you are there at least 9:30. You might find that the other side want to talk to you. They may be wanting to try to reach an agreement with you and have a discussion before you get into the court. But even if that's not the case, make sure that you turn up on time. Turning up late is only going to annoy the judge. Mistake number two, dress appropriately. A lot of times I see people who are representing themselves turn up in quite the flamboyant outfit. The court's always put off by that, so make sure that you are plain and simple but smart. Don't dress casual if you're attending the courtroom. Mistake number three, make sure any evidence that you wish to rely on is filed on time. A lot of times I see people arriving at court and presenting the judge with a statement that I haven't even seen. Lots of exhibits attached to it as well. Because I haven't had a chance to read that before the hearing, I'm going to object to it being submitted into evidence, and chances are the judge is going to agree with me. So if you've put together a statement that has exhibits, make sure that you file them a good week, if not 2 weeks before your hearing date. That way, as your opponent, I've got time to read it, but also, and more importantly, the court's got time to read it prior to your hearing date. Mistake number four, make sure that you keep your evidence short and to the point. I totally get that this case is specific to you, but what you've got to try and remember is that the court have heard hundreds, if not thousands, of similar cases, whether they be child custody cases or finances following your divorce. Recognise that the court's going to be looking to identify the important parts of your evidence. Recently, I had an opponent who submitted a 150-page statement. The statement itself was only about 8 pages long, but there was over 140 pages of exhibits. I guarantee you no judge is going to want to sit and go through all of that. So make sure that you only submit relevant evidence that's really key to supporting your argument. Mistake number five, make sure that any information or evidence that you wish to submit to the court is relevant to your case. I get that a lot of people get emotionally involved in their matter, particularly where they're representing themselves, and they think that the court need to hear chapter and verse about the state of the relationship and what the ex did. A lot of times it's simply not relevant. So just keep the information on a need-to-know basis. Mistake number six, try to speak from the heart. Don't bring in a script that you then want to read from. Chances are the court's going to zone out if you're stood there reading pages and pages of pre-typed material. It's your case. Know that no one knows it better than you. Be confident in the facts that you want to rely upon and why the court should favour your argument. Mistake number seven, be really aware about what you're putting on your social media. That can be used as evidence by the other side. So for example, if the other side are making allegations that you are an unfit parent, perhaps you party too much, they say, perhaps you drink too much, what you don't want to be doing is posting all over your social media page the fact that you were out last weekend or the fact that you've just returned from a holiday in Ibiza, because that just gives their argument more strength. Equally, if you're running your own finance case and perhaps you're looking for a larger share of the matrimonial assets, more than 50-50, or spousal maintenance from your ex, don't be posting about what you're spending your money on. Keep your social media private, at least until the court case is over. Mistake number eight, just because you are representing yourself, never feel intimidated. If you don't understand something that's being said, or your opponent is using lots of legal jargon, ask for them to explain it to you. Most judges will be more than happy to walk you through the process and explain exactly what your opponent is saying. They may even ask your opponent to use plain English. This is your case. Don't worry that you don't know all of the legal jargon that lawyers will use. It really isn't that important. Mistake number 9, and if I'm honest, the most frequent mistake that I see being made in court by people who are representing themselves. Keep your emotions in check. All too often, I see people getting angry, getting fed up, getting emotional where they start to cry. All you're doing is distracting from what you want to say. I get that it's difficult because it's your case. You are emotionally involved in it. But if you're going to represent yourself, know that the court don't want to see any of that. I remember one hearing I did and the guy got so angry, he lifted the water jug and threw it at the judge. Needless to say, he lost his case. But it just demonstrates my point. No matter how bad you think the hearing is going, or perhaps you think the judge isn't hearing your points, take a moment, take a breath. Ask for a 5-minute adjournment, take a glass of water, but just keep the emotions in control. Mistake number 10, not keeping focused. I see all the time where litigants in person just run away with their argument and start referring to all kinds of irrelevant information that the court simply don't need to hear, but more importantly, don't want to hear. If you're in the middle of a case about your children, keep it focused on the children. Know that what the court wants to hear is what is in the child's best interests. You can download that from the government website to help you stay even more focused when you're delivering your argument. And equally, if you are representing yourself in a finance case, talk about the assets that are in the marriage, bullet point them if you need to, and then address the court as to what you think will be a fair and reasonable outcome based on the finances that you need. So there we go, guys. Top 10 mistakes that I see people make when they're representing themselves in court all the time. Be sure not to make those mistakes, and I think going forward you'll have greater success in winning your argument. Over the years, I've done other videos to help people who are representing themselves in court. So if this video helped, then feel free to check those out as well. So I hope you enjoyed that video, guys. Don't forget to like and subscribe.